By the end of this hearing, the uniform that once commanded fear would no longer protect the man wearing it. The badge that opened doors would become weight, and the power that had gone unchecked for years would finally run out of room to hide. At exactly 9:07 a.m. on Monday, October 14, 2024, the bailiff called Courtroom 4B to order inside the Westbridge County Courthouse, a stone and glass building that sat at the intersection of Alder Street and 9th Avenue. Outside, traffic moved as usual. Inside, everything slowed down. I took my seat behind the bench without urgency. No dramatic entrance, no raised voice, just the sound of a chair settling and papers being placed in a precise stack. The room rose, then sat again, and silence followed naturally. Silence, when allowed to exist, tells the truth faster than noise ever could. I looked across the courtroom deliberately. Wooden benches worn smooth by decades of hearings. A row of reporters along the right wall, notebooks open but pens still. A handful of uniformed officers standing near the back, their posture rigid, eyes forward, faces unreadable. And at the defense table, seated slightly too comfortably, was the defendant. This courtroom, I reminded everyone, is a place of equality. Not symbolic equality, real equality, the kind that does not bend to rank, reputation, or relationships. Inside these walls, I said calmly, no one is more important than the law, and no one is beneath it either. Titles are left at the door. Power does not speak here. Evidence does. The defendant before us that morning was 52 years old. His name, for the purposes of this record, is irrelevant. What mattered was his position. For nearly 17 years, he had served as the chief of police of Northbridge City, a suburban municipality 10 miles east of downtown Westbridge, a department of just over 100 officers, a tight-knit community, and a man accustomed to being the final authority in every room he entered. He came from a background that rewarded confidence early, raised in a law enforcement household, father a deputy sheriff, uncle a city councilman. He entered the academy at 22, rose quickly, learned which conversations mattered and which ones never made it past closed doors. By 40, he was wearing gold trim on his uniform. By 50, he had not been meaningfully challenged in years. That matters. Not because success is a crime, but because unchallenged authority changes behavior, slowly, quietly, until someone forgets the difference between respect and fear. The charge before this court was not complicated on paper. Reckless endangerment, abuse of authority, obstruction, conduct unbecoming of a public official, each count tied to documented incidents with precise timestamps, video evidence, and sworn testimony. What made this case different was not complexity. It was disbelief. Disbelief that someone in his position could act as if rules were optional. The first incident occurred on Friday, June 21, 2024, at approximately 11:43 p.m. The location was Riverside Parkway, a 4-lane road running parallel to the river on the south end of Northbridge. Speed limit posted clearly at 35 miles per hour. Residential area, dim streetlights, pedestrian crossings every quarter mile. According to traffic camera footage later submitted into evidence, a black, unmarked SUV entered the stretch, traveling at 58 miles per hour. Windows tinted beyond legal limits. No emergency lights, no siren. The driver did not slow as the road curved near Maple Bend, an area where visibility dropped sharply after dark. Inside the vehicle was the defendant, off-duty, wearing plain clothes, returning home from a private dinner at a local restaurant. No call, no emergency, no authorization. At 11:44 p.m., a cyclist crossing at the marked intersection of Riverside and Glenwood Avenue narrowly avoided impact. The cyclist, age 19, later testified that he felt the vehicle pass close enough to move his jacket. The SUV did not stop, did not slow, did not signal. It disappeared into the dark. 2 minutes later, at 11:46 p.m., the same vehicle was captured on a residential security camera, turning sharply onto Hawthorne Drive. Tires squealed. A trash bin was struck and knocked over. No damage reported, no report filed. The following morning, a resident submitted footage to the department's public tip portal. That submission was routed, per policy, to the chief's administrative office. It was closed within 12 minutes. No investigation opened, no internal report generated, no explanation recorded. The system log shows the case marked as resolved, no action necessary. When asked later who authorized that closure, the answer was simple. He did. In isolation, that might have been dismissed as poor judgment, a warning, a reminder, the kind of moment where authority corrects itself quietly. But authority only corrects itself when it believes it can be corrected. The second layer of this incident unfolded online. At 2:18 p.m. on June 22nd, less than 15 hours after the near collision, a short video was posted to a private social media account linked to the defendant. The account had approximately 18,400 followers, mostly local residents, officers, city employees, community members. The video was filmed from inside a vehicle, the dashboard visible, speedometer blurred but recognizable. A caption overlaid in white text read, "Late nights, empty roads, perks of the job." The video remained up for 4 hours before being deleted, but deletion does not erase impact. Screenshots were taken, shared, saved. One of those screenshots made its way to the desk of an assistant city manager by Monday morning. That was the first moment this court would later identify as a turning point, not because of speed, not because of the road, but because of intent. The quiet message that rules were something other people worried about. I watched the defendant as these details were read into the record. He sat back in his chair, one arm resting on the table, jaw tight but composed. No visible reaction, no acknowledgement. A man used to hearings where outcomes were decided long before the room filled. When asked if he understood the charges as stated, he answered yes, without hesitation. Understanding is not the same as accepting. The prosecution did not rush. They never do when the evidence is patient. They introduced still frames, timestamps, aerial diagrams of Riverside Parkway, speed calculations verified by independent analysts, everything clean, everything calm. The defense, in response, suggested familiarity with the road, experience, an absence of malicious intent, a long career of service. Service does not excuse endangerment. Experience does not permit exemption. At 10:11 a.m., I called for a brief recess, not because the court needed time, but because the defendant did. As he stood, he glanced briefly toward the gallery, where 2 junior officers from his department sat stiffly, eyes fixed forward. Loyalty is complicated when authority is on trial. When court resumed at 10:28 a.m., the air had changed slightly, not louder, heavier, and we had not yet reached the part of the story where warnings were ignored. By the time court resumed, the defendant had settled into a posture I had seen many times before, shoulders back, chin level, the stance of a man who believed this was still a misunderstanding that would resolve itself. Power, when questioned for the first time, often mistakes scrutiny for inconvenience. At 10:31 a.m., the prosecution moved into the next phase of evidence. This was no longer about speed or a late-night drive. This was about pattern. On Tuesday, July 9th, 2024, at exactly 3:42 p.m., the defendant entered Northbridge City Hall through the west entrance. Surveillance footage shows him bypassing the security desk without signing in. A junior clerk can be seen hesitating, then stepping aside. He was not challenged. He never had been. At 3:47 p.m., he entered the records office on the 3rd floor. The office handles internal affairs files, public complaints, and disciplinary records. According to building logs, only 2 people are authorized to access those cabinets without written request. The defendant was not one of them. He opened cabinet C, removed a file, closed the cabinet, left the room 3 minutes later. That file belonged to Officer Daniel Ruiz, age 27, a patrol officer with 4 years on the force. Officer Ruiz had filed an internal memo on June 24th regarding the Riverside Parkway incident. He had noticed discrepancies between traffic camera logs and the closure report. He did what policy required. He documented it. He submitted it. 2 days later, His memo disappeared from the system. Officer Ruiz testified on August 3rd that he was called into a private meeting with the defendant at 8:15 a.m. The meeting lasted 7 minutes. No recording, no notes. According to Ruiz, the defendant told him calmly that some things don't need to be chased and suggested he focus on real police work. Ruiz was reassigned to night patrol the following week. None of this involved raised voices. None of it required threats. Authority does not need to shout to be understood. At 11:02 a.m., the prosecution introduced a second social media incident. This one occurred on Saturday, July 13, 2024 at 9:06 p.m. The defendant attended a private backyard gathering at a residence on Cedar Ridge Lane. Neighbors later described it as a loud but contained event. Alcohol present, music audible beyond the property line. At 9:41 p.m., a patrol unit responded to a noise complaint. The responding officer was a 31-year-old sergeant with 9 years of service. His body camera footage was played in court. The footage showed the patrol car stopping at the curb, the officer exiting, the defendant stepping into frame within seconds. No greeting, no introduction, just a sentence delivered flatly. "You can leave. I've got this." The officer hesitated, asked if everything was okay. The defendant leaned closer to the camera and said, "You're done here." The officer complied. The video cut off moments later, but before it did, the defendant turned toward someone off camera and laughed. That laughter mattered, not because it was loud, but because it was recorded. The following morning, at 11:18 a.m., a clip from that footage appeared online. Cropped, edited, 30 seconds long, captioned, "When training meets experience." The account posting it was private. But private does not mean contained. Within 2 hours, the clip had been shared across local forums. Comments ranged from amusement to concern. One comment, time-stamped 12:06 p.m., read, "Is this how it works now?" The clip was deleted by 2:30 p.m., but again, deletion does not erase impact. At 11:46 a.m., I asked the defendant if he recognized the footage. He said yes. I asked if he believed his actions were appropriate. He paused, then said, "I handled it." Handling is not the same as accountability. At this point, the courtroom had grown quieter, not tense, focused. The reporters had stopped whispering. The officers in the back no longer stood rigid. They stood uncertain. At 12:03 p.m., the prosecution rested temporarily and requested the court hear testimony from a community witness. A woman in her late 60s approached the stand. Retired school administrator, resident of Northbridge for 32 years, she testified about Riverside Parkway, about how children crossed there to reach the community center, about how she had stopped biking after dark because cars moved too fast. She did not mention the defendant by name. She did not accuse. She simply described fear. Fear is not abstract. It is built moment by moment. The defense objected twice. Both objections were overruled. At 12:27 p.m., we broke for lunch. During recess, the defendant remained seated longer than necessary. He watched the room empty. Power notices absence more than presence. When court resumed at 1:19 p.m., the defense shifted tone. They spoke of stress, of long hours, of the burden of leadership. They presented commendations, awards, letters from colleagues. I read each one carefully. None of them addressed July. At 1:58 p.m., the prosecution introduced the final piece of evidence for the day. This was the moment where the room changed. On Thursday, August 1st, 2024, at exactly 6:12 p.m., the defendant was driving northbound on Elmcrest Avenue. Speed limit 25 miles per hour. Residential. Narrow. Cars parked along both sides. A dash-mounted camera from a civilian vehicle captured the defendant's SUV crossing the center line to pass a stopped school bus with its lights engaged. The stop sign arm was extended. Children were visible near the curb. The SUV did not stop. At 6:13 p.m., the video shows the SUV accelerating. At 6:14 p.m., the video ends. No emergency, no lights, no siren. At 6:21 p.m., the civilian driver submitted the footage to the state traffic safety portal. At 6:39 p.m., the submission was flagged due to the vehicle's registration. At 7:02 p.m., the footage was locked from deletion. That lock was not placed by the department. It was placed by the state. The defendant had been warned after June. In writing, quietly, internally. He knew scrutiny existed, and still, he chose himself over safety. When the footage played, the defendant did not look at the screen. He stared straight ahead. His jaw tightened. His hand curled once, then relaxed. At 2:17 p.m., I asked a single question. Do you dispute the authenticity of this video? He answered, no. That answer closed a door. At 2:34 p.m., I called an early adjournment for the day. Not out of kindness, out of necessity. The weight of evidence had reached a point where rushing would do harm. As the courtroom emptied, I remained seated. I looked at the bench, at the seal behind it, at the empty chair where the defendant had sat. Mercy requires humility. And humility had not yet entered this room. We had reached the point of no return. By the time the final session began the following morning, the outcome was already forming, not in my mind, but in the record. Courts do not decide based on instinct, they decide based on accumulation. And this case had reached the point where accumulation no longer allowed ambiguity. At exactly 9:02 a.m. on Tuesday, October 15th, 2024, Courtroom 4B was called back to order. The defendant entered with less confidence than the day before. Not panic, not fear, but awareness. Awareness that explanations had expired. I began by summarizing nothing. Summaries are for conclusions. Instead, I addressed the room calmly and reminded everyone that the purpose of this hearing was not punishment for status, but accountability for conduct. Authority, I said, is not dangerous by itself. Authority becomes dangerous when it believes it cannot be corrected. The defense requested leniency based on decades of service. I listened. They spoke of reputation, of leadership, of the impact incarceration would have on morale within the department. They suggested that public discipline alone would suffice. I let them finish. Then I spoke, not louder, not faster, but with clarity. I explained that this case was never about a single mistake, not about speed, not about a party, not about a social media post. It was about repetition after warning. It was about choices made once consequences were visible. And it was about a pattern of conduct that placed convenience above safety. I spoke about Riverside Parkway, about Elmcrest Avenue, about school buses and cyclists and residents who trusted the badge to protect them, not intimidate them. I spoke about Officer Ruiz, not by name, but by role, about what it means when younger officers learn that policy applies selectively. Then I paused. I spoke about children, about how they do not understand rank, about how they trust signals, lights, stop signs, uniforms. I spoke about my own grandchildren, about how they cross streets believing adults will stop, believing rules are real. Unchecked privilege, I said, teaches the wrong lesson quietly. At 9:41 a.m., I delivered the verdict. On count 1, reckless endangerment, guilty. On count 2, abuse of authority, guilty. On count 3, obstruction, guilty. On count 4, conduct unbecoming a public official, guilty. The defendant did not react. He did not need to. The law had spoken. Sentencing followed immediately. I ordered 12 months of consecutive incarceration to be served in a state facility outside the county he once supervised. No weekend confinement, no alternative custody. Jail time exists, I explained, to remove opportunity for harm, not to humiliate. I imposed fines totaling $75,000, not symbolic, but proportional to the damage caused and the trust broken. Fines exist to remind that power does not purchase exemption. I ordered the permanent revocation of his driver's license for 5 years. Driving, I said, is not a right when safety is disregarded. I ordered 1,200 hours of community service to be completed after incarceration, working with traffic safety education programs, not as punishment, but as exposure to the people affected by choices like his. Finally, I ordered his immediate and permanent removal from any law enforcement role within the state. Authority once abused cannot be returned unchanged. There were no gasps, no outbursts, just silence. I addressed the room one last time. To young people, power earned must still be governed. To parents, teach your children that rules apply even when no one is watching. To privileged families, protection is not inheritance. Then I adjourned the court at 10:06 a.m. The defendant was escorted out without ceremony. The badge he once wore was not mentioned again. Justice, when done correctly, does not shout. It simply stands.